And welcome to the Week 14, Chapter 14 video lecture. We're going to be going over sentencing this week, a very important aspect of the criminal justice system, as you might imagine. Let's go into the learning objectives for this chapter. First, we're going to distinguish between the 5 major sentencing philosophies. These have to do with essentially why are we sentencing, why are we punishing, and they come down to retribution, which is the big one, deterrence, which is probably second in line, rehabilitation goes down the line, incapacitation is another one, restoration is the last one. So these are the general sentencing philosophies that we're going to be covering. We're also going to describe how the 3 branches of government are involved in sentencing. This includes the legislative, judicial, and executive. Also, we're going to recognize the main objective of changes in the sentencing structure beginning in the 1960s and the major consequences of the changes that we've seen since then. And then we're going to outline how the U.S. Supreme Court has limited both state and federal sentencing guidelines by its power to interpret the United States Constitution. Now, we're going to also explain the law in action perspective on researching the impact of mandatory minimum sentences. Of course, the law in action perspective says we want the law to be very strict, strictly adhered to, and mandatory minimum sentences are part of that perspective. And so we're going to see how the research has indicated the true impact, as much as we can determine, of the mandatory minimum sentences that have become so popular more recently. And next, we're going to list at least 3 major issues related to imprisonment as a sentence in the United States. And we'll see there are many, but 3 for sure we're going to go over. And this will relate often to whether a judge will send someone to prison, because sometimes it could be counterproductive based on these issues that come up. All right, next we're going to identify the major alternatives to prison, and there are many, but we'll get into the major ones for sure. That gives the judge a certain number of alternatives that they can try before they send him to prison if they have to in the first place. All right, we're going to summarize the 2 United States Supreme Court rulings from the 1970s on capital punishment that led to bifurcated processes for death penalty sentencing. Essentially, what that means is that when we go to trial on a capital case and where someone could be put to death as the result of the case, then the first thing will be a guilt phase where the jury will enter a verdict, hopefully, on the issue of guilt. If they find them guilty of the crime that would potentially give them the death penalty, then there'll be a sentencing hearing where then the jury will decide on whether death is the appropriate sentence. And in some places, like in California, if there's a death penalty verdict by the jury, the judge must also agree to that death penalty. So it has to be unanimous throughout every fact finder in the entire system. All right, next we're going to indicate how the court has narrowed the list of death-eligible cases and offenders, and they've done that in several ways over the past few decades. We're going to define the concept of normal penalties and indicate the 2 most important factors in determining normal penalties. These normal or norms in penalties become part of the courtroom work group, as you might imagine, because people, get to these norms eventually, and they become part of the working mechanism for deciding on what is the proper sentence in the case. All right, we're also going to distinguish between the concepts of sentencing disparities and discrimination. We will see that there are very real sentencing disparities and claim discrimination, and certainly much of it is true. But the disparities come with the fact that, for instance, black males have a gigantic disproportion in terms of the amount of sentencing and the punishment they are given versus their white counterparts for similar crimes. And so that becomes a big issue for whether we have fair justice or not. All right, let's first ask the question, why do we punish lawbreakers? And there are 5 different philosophical principles. One is retribution. Retribution just means payback. It's an eye for an eye kind of justice. You take out my eye, I take out yours. It can even mean you take out one of my eyes, I take out both of yours. Depends on how you want to look at the retribution, but it is punishment. It's pure and simple punishment. It is consequences for bad acts, and hopefully the amount of retribution fits the crime kind of concept. But it is the major philosophical principle behind punishing lawbreakers. Next is deterrence. We want to have this punishment available and ready, and we want everyone in the world to see how it has been implemented with certain offenders, so that the reality of the penalty for being caught and convicted of these crimes becomes well aware among all the people who might be thinking about breaking the law. And so we want everyone to know what those penalties are. You might see on TV every once in a while commercials, typically public interest commercials, where they're talking about what it would cost you if you got a DUI. And it's a sobering thought, by the way. In most jurisdictions, they hit you very, very hard. And your biggest loss in terms of dollars is not even the fine of, in California, it might be $2,500, for instance, but it's your insurance cost that's going to go up so dramatically that really hits it. Forget about even the attorney's fees to try to defend yourself. Okay, so deterrence is a big deal. It's certainly number two. Next is rehabilitation. We hope by punishing people, we deter them from continued law breaking, and thereby bring about a rehabilitation. We also, if we can do this, we will tend to actually bring on programs and help in many different ways to try to give people who have been lawbreakers the opportunity to actually get back into the legitimate world in a meaningful way, so they can make a living on their own without having to steal or whatever they've been doing. All right, incapacitation is the next philosophy, and that has to do with the fact that if you have someone in prison, they really can't do, although they can do crimes in prison, and they do, and if we have certain gang offenders, they can actually call out crimes to be done outside of the prison, but generally speaking, they are incapacitated. They can't create those crimes, and in most cases, other than the gangs where they can call out crimes outside of the prison, it incapacitates the person. So you have a rapist, for instance. They're not going to be raping any woman on the outside while they're in prison. So we have got them incapacitated. So that's a benefit for society, is that there's a certain number of years we don't have to deal with that person, and that leaves that one person not committing crimes that we suspect they would likely commit if they were out on their own. And next is restoration. We want to restore the person to the basically a law-abiding citizen kind of thing, and it's gone along with this movement you may have known something about even outside of your learning in this class, and that's called restorative justice. And it's based on three distinct elements. First, that the crime is primarily a conflict between individuals, resulting in injuries to a victim, to the community, and even to the offender. And therefore, the crime is only a secondary violation of the government laws. And number two, the principal aim of the criminal justice system should be to repair these injuries. And number three is the criminal justice system should facilitate involvement of victims, offenders, and the community, rather than emphasizing the role of professionals who deal with these offenders and sort of isolate the victims and the community from the role of restoring the relationships that have been damaged based on the crime that took place. Okay, so restorative aspect of justice will only work in cases where we are not dealing with violence towards the victim. We do not expect victims to be involved with someone who's been violent towards them, especially one that they did not know. They want to be as far away from that person as possible, and we certainly can't blame them. But if you had, let's say, a teenager who vandalizes an old lady's house, well, maybe we could actually have the community Monitoring this kid. Maybe we could have them, as part of their consequences for their crime, go out and repaint the lady's house. And it's going to take them a long time to do that. He's going to spend a lot of time they could have spent out having fun repainting this lady's house. Well, the victim's going to be repaired. The community will be involved in the process. The offender will see that the community is there, is watching out, and has certain expectations with regard to the behavior of that child. And that will be a good example of restorative justice. Okay, so that is to some extent involved, but only in certain cases, because certain cases are not appropriate for restoration justice. All right, these sentencing philosophies will often compete with each other. So, for instance, do you really want to rehab someone who is on his second first-degree murder, with special circumstances indicating they should probably be put to death for what they've done, especially if they were involved with other types of crimes like raping women and killing them, kind of thing, the stuff that just curls the hair on the back of your neck kind of crimes. Do we really want to be involved with rehabilitation? Do we really even have to deal with it? We certainly want to deal with incapacitation. And restorative justice is completely out of the line entirely. Deterrence? We don't know how much putting someone to death is actually going to deter others from murders, but it's probably still there. Retribution is definitely there. And so you can see how sometimes these things get in each other's way. But we do have to look at each philosophy and balance them based on the crime that was committed and the aggravating and mitigating factors. Okay? All right, let's continue on. Now, retribution. Let's go into that in a little bit more detail. Societies since way, way back in the Lex Talionis have held people responsible for their actions. Where they hurt other people, where they hurt society, we're going to give them punishment. It's called just deserts. It's called eye for an eye justice. We look at it in terms of proportionality. Often people think that it should be an eye for an eye rather than two eyes for one eye, but that's not always true. But at least we're looking for proportionality. Again, if something is very, very aggravated, we may want to give someone more losses than they have taken, so to speak, assuming we can do such a thing. And we're also looking at expiation. Expiation is a word that essentially the people who believe in retribution believe in it not because the punishment itself, but because it allows for an atonement for the sins of the perpetrator through deserved suffering, rather than just simply for the purpose of payback. And so that's what we're dealing with when we're doing expiation. So you can see that even though punishment may be part of all of this, there may be different theories upon which punishment may be justified. Okay? All right. Deterrence. Again, the main purpose of deterrence is to prevent future crime. We look into this sort of hedonistic calculus and decide on this weird idea, and it tries to put deterrence into a mathematical formula, more or less. And what that means is we should not give someone more time in jail or prison or more punishment than would be necessary to deter them from committing the crime in the future. So what that means is if you are a first offender, we will not probably have to give you as much punishment to change your ways. If you have been a career criminal and we keep bringing you in every other year on very serious crimes, we have to give you gigantic penalties because we don't seem to be able to communicate well, because you've been seeing increased penalties every time, and now you just continue to do it anyway. So you're sort of incorrigible, and so we then will up our mathematical formula but the ultimate is it has to equal the total number of years it would be, and only that number of years that is necessary to prevent the person from committing the crime again. And again, it's just we're just trying to put it in a mathematical formula. Nothing about it is perfectly true by any means. It's just that's what we try to do because we aren't trying to give any more deterrence than we need, and nor does society want to pay for more deterrence than they need as well. And then there's the general deterrence idea, and that has to do with the fact that when we punish one person, we like to see that other people get a chance to see what happens to that person, so that there's a general deterrence among all people who might be thinking about doing a certain unlawful act. And then there's specific deterrence, and that's had to do specifically with the individual who we are dealing with for sentencing at the time. And certainty and severity of punishment is also important to deterrence, meaning you don't want to let people believe that that there's little chance that they're going to be convicted, and if they are convicted, little chance that they'll be given any meaningful punishment. You do that, and you've basically thrown deterrence out the window. In their calculus, they'll say, even if I got caught, I'm not going to get very much punishment. And by the way, I'll give you a good example of that in California. After AB 109 was passed, you cannot go to prison for selling drugs in California under California law. There's only one exception to that, and that's selling drugs to a minor. But what that means is that you can only go to county jail, and county jails are booked up. You probably won't do more than a few days in jail at best, even if you were the Medellin connection to cocaine under California law. And that is pretty well decided on the issue that deterrence just is not there any longer. It is just not there. And the reason for that was that 40% of the people in prisons were on drug charges, and we just couldn't afford it any longer. We couldn't keep building prisons. We couldn't do it. Okay, and let's look at the utilitarian theory of deterrence. The utilitarian theory of ethics says that we should choose the option that gives the most number of people the most amount of benefit. So we sort of turn that around under deterrence. And the objective of the utilitarian theory for punishment is that the punishment should discourage crime by making it painful, so that we are, essentially, helping out the most number of people by making the punishment as painful as is necessary to prevent the crime from being perpetrated again, both generally and specifically. And by the way, this deterrence theory, every bit of the deterrence theories rest on the assumption of rational behavior. That means that people will look at the penalties they've been given for their crimes and say at some point along the line, the penalty is too great for what benefit I am getting out of my behavior, and they'll stop it. Well, we all know that's not the way it is in many cases with criminals. They are often irrational when they make decisions to commit crimes. They are also often impulse crimes. It's not something that you would think about before you did it. Some very, very cold and calculated white-collar crimes, and maybe some of the very sophisticated burglaries where you have to get into alarmed facilities and pre-plan those sort of things. There might be rational behavior there. But otherwise, no, and especially in the big crimes where there's lots of violence. Those, you're just not going to see it. All right, let's look at rehabilitation. Rehabilitation says we should treat people rather than punish them. Although remember that we look at all the different aspects of sentencing. So there's no reason why we cannot punish and treat at the same time. And in some cases that's appropriate. But the idea of rehabilitation is that we should feel sympathy for this person for the crimes they've committed, which is kind of strange. But it means that we should try to make them a better person as a way to deal with the crime problem. So one good example of rehabilitation is probation. Probation is a process by which it's a process of judicial clemency is what it is. We will not sentence you to do your full time. We may give you some time, but we'll give you your full time, conditioned on you agreeing, because you have to agree to probation. You can't do it involuntarily. on you agreeing that you will meet all of the requirements of your probation for a specific period of time. So it may be you're placed on probation for 3 years. You know, you give up all of your Fourth Amendment rights. You give up all your um, rights for probation officers to come in your house and search anytime they want to, and many other conditions like no contact with the victim, make restitution to the victim, um, do not commit any further violations of law, that kind of stuff. So we keep watch over you, and the probation department actually does keep watch over you as a probationer. They monitor you depending upon, if you're considered someone who's a good risk for future crime, they're going to monitor you very closely. If you're not someone who they think is going to be likely to commit a crime in the future, you'll be given less monitoring. And parole is the same sort of thing. Parole is um, the same thing as probation, except it's when you've been in prison and we release you sooner than your sentence would indicate you should be released. You are released conditionally on meeting the terms of the parole. If you do not agree to the parole, you will not be paroled. You give up your Fourth Amendment rights, you give up lots of different rights so that you can be monitored. You are monitored. You may not do any more criminal acts, and you have to go out and get a job. All this sort of stuff is all in the terms and conditions. If you don't meet those terms and conditions, you can be then sent back to prison for more time, or maybe the rest of your sentence altogether. And sometimes the sentence is a life sentence, so they could send you back for the rest of your life. All right. There's also what's called pretrial diversion. This is very, very popular in drug possession cases, where it's possession of small amounts, that is just usable amounts of drugs. So we sort of think that you're not a drug dealer, you are a drug user. We know there's a problem with drug use, but we don't necessarily want to put you in jail for that. It's very expensive to do that. We don't think that really deters you very much. And so what we will do is we will, prior to any trial, prior to any dealing with the case itself, you will be given a voluntary diversion to a program where you're given counseling on how to get off drugs. You have to go through that program. If you successfully complete the program, they will dismiss the case or perhaps give you a lower sentence. Depends on what the diversion program is. And then there's what we call evidence-based corrections. And evidence-based simply means that we go out and we do studies on certain rehabilitation techniques and programs to see how effective they are in preventing recidivism among those who complete the program. And so what happens here is we will use the evidence-based correction rehabilitation programs to try to cut back on the number of people who keep coming back into prison all the time. Now, evidence-based is important because we don't want to just simply say, let's give them a program, spend a lot of money on it, not even know for a fact it's going to do anything. No, what we do is we typically have these representative programs that often private organizations will put together based on psychological, sociological principles. They will run it for a period of time. They will collect statistics on it, and they will show the government, for instance, that it is a successful program, and then they will sell that program to the government as a means of an evidence-based correction rehabilitation program. And so then the government, if it likes that program, will bring it into their rehabilitation programs for criminals. And next is there's a public safety realignment. What that is the transferring of the state's responsibility for lower level drug offenders, thieves, and other non-violent convicts to the county level. So what happens is we send people who are really not dangerous to people's physical well-being to lower level facilities. We transfer them there. We basically realign them from what would be a prison sentence to a county jail sentence. Okay. And next is sentences should fit the offender rather than the offense. And so what that says is that what the offender should get should be sufficient for that offender to be properly incentivized to complete rehabilitation programs and really want to get better. you can overdo it, so to speak. You can hit them so hard that they hate society and they'll do anything they can to do bad things to society because they want to pay society back because they think they've been unjustly treated. If you give them a little less sentence and you give them and it's justified and they don't feel like it's out of line with what they did, then they may very well decide that rehabilitation is a good program for them, and then that's essentially what we want. Incapacitation assumes crime prevention through this process of putting someone in jail or prison. It is future-oriented. It essentially is simply a concept that the more years we give somebody, the more incapacitation we are giving to them in terms of their ability to hurt people outside in society. It focuses on personal characteristics of the offender, so that if this person is always and every time you turn around doing violent acts to people, incapacitation is extremely important. For whatever time we can put them in prison, it's time we do not have to deal with them, at least outside the prison, in society. The limitations, of course, there's no standards for the length of sentence based on incapacitation. Is a rapist someone who, 10 years is long enough? Some people would say no. Some people say it has to be a life sentence because you'll never stop them from raping, ever. All they'll do is get better at it and less likely that you'll catch them. Also, there's a lack of focus on reform that may result in worse future behavior. So if all you're talking about is incapacitation, you're not trying to reform them, although some people also say certain types of criminals are not reformable, but that's another question. Imprisonment is a temporary solution, obviously, because if they're going to get out at some point, and then they're back out in society ready to do whatever they feel like they want to do. And then there's also this concept of selective incapacitation. And this is very much like or part of the three strikes laws. There are certain people out there that we know are very dangerous. They've been dangerous. They've demonstrated over and over again. And so we essentially target them for very lengthy prison sentences because incapacitation becomes the most important aspect. We're pretty sure we're not going to change the way that they're dealing with people. They're going to hurt people if we let them out. There's nothing we can do about it. That's just who they are, and they are incorrigible. So we have really no choice but to incapacitate them. Let's get them out of society. Yeah, so that's when that becomes very important. All right, restoration. Again, it seeks to replace retribution, although it doesn't always, because sometimes retribution goes along with restoration. But restoration is to restore the relationships between the victim, the community, and the perpetrator. Okay, that means restoring them back to what they were before the criminal act destroyed or damaged the relationship between these parties. They think of crime as a conflict between individuals, and crime is only secondarily a violation of government laws. And the principal aim would be to repair the injuries that have occurred, to repair the relationships. And that way we put somebody back into a good position in the community, and it has its values. Again, it's not something you can do with people who are violent, and certainly not recidivism violence at all. That's not something we could ever put up with because that would be subjecting the victim and the community to direct involvement with a perpetrator that's going to get them probably victimized once again. All right, the criminal justice system should facilitate involvement of victims, offenders, and the community together as part of this restoration process. It's called restorative justice, and it has its value, again, in certain types of cases where it is possible to mend the relationships, and only in those cases would it be any good. Let's look at a thinking point here. We have the Maricopa County, Arizona county jail system. It's very famous, as you probably have heard. It was Sheriff Joe Arpaio's brainchild, so to speak. And they explain, or we should be able to explain what kind of concept of sentencing that you believe in this particular county jail system. Now, just for those who might not remember exactly what this is, he has a county jail system where people are put in tents out in the desert under not deplorable conditions, but they're clean and they're livable. But you won't find any air conditioning, you won't find any televisions, you won't find any radios. You're basically isolated, and If you want to work, you can still reduce your sentence. If you don't want to work, you're just going to sit around and do pretty much nothing. The food isn't very good. It's livable, but that's about it. You're given basically the minimum that you need to survive, but you're not given so little, of course, that you're going to starve to death, of course, but you're going to give enough food, but you're not getting anything else. Nothing else. None of the nice things that we have in our society will you get. What does that do? What is the concept here? What is the sheriff trying to do? Yeah, if you talk about retribution, you're probably right on target, because that's what he's doing. He's saying, I cannot physically torture you, but there's no reason why I have to give you anything more than some sort of little bit of shelter, and none of the niceties of life of any kind, and that's all. That you're going to be miserable while you're here, and hopefully, because you're miserable while you're here, you're not going to commit crimes when you go out again. Now, the question is, do you believe this concept works? Why or why not? Think about that. Think about whether you think that works. And I'll make a bet it works on some people and doesn't work on others, in my experience as a DA. And does the sheriff's conviction impact your views of his sentencing philosophy? Why or why not? What concept would you use if you were running a jail or a court system? Would you go about the same type of situation? Should people have internet? Should they have television? Should they have air conditioning in jail or prison? Should we make it easy on them? Should we, make it essentially a, I don't know, one of those um, places where you go on vacation, where you have a good time? Is that what you want? Is that going to do good things for the system or not? And if not, where do you draw the line? How much do you give them in terms of creature comforts while they're in doing their custody time? All right, restorative justice. 3 elements. Crime is primarily a conflict between individuals, which results in injuries. The principal aim of the criminal justice system should be to repair these injuries, and the criminal justice system should facilitate the involvement of victims, offenders, and the community. And so your question then in this situation is, should restorative justice replace revenge-based sentencing? And I can give you my opinion, but of course I want you people to think of your own. But restorative justice can be very good for specific kinds of crimes where there is a good chance that you can actually repair the relationship between the offender and the community, and the offender and the victim. If that's not likely, it is the worst thing you can possibly do, because all you're going to do is subject the victim and the community to further possible crimes and harassments and so on. Do nothing for them, and do nothing for the perpetrator either, because that perpetrator is going to think, what in the world are you doing? If this is what I get for what I did, I'm going to continue to do it. So some offenders are not appropriate for this, and so it's only a limited number of offenders and types of offenders that would work with this. All right, sentencing responsibility. That's a big question. Who should have sentencing responsibility? Well, let's look at the ones that actually do. First, legislative. That means that when the legislature defines a crime, they also define how much time a person can be sentenced to. Sometimes there's mandatory amounts of time that have to be sentenced to. Other times it gives the judge leeway to give them no time and probation, or all the way up to the maximum amount of that the legislator has put into the law. Then there's your judicial course. The judge actually decides on sentencing. They have legal requirements. They may have to give a certain sentence if it's mandatory. They may have great discretion if it's not mandatory. And they are limited by the total amount that the law will allow. You cannot essentially sentence someone to more time than the law allows. Then there's the executive branch, which is the DA first. They have influence on sentencing for a lot of different reasons. One is that they can adjust the charges so the person cannot be given more than a certain number of years. They can also throw the book at them so they can get the maximum number of years. They also will argue for sentencing, so they have some influence on the judge as the representative of the people. And then the second part of the executive branch is the actual corrections facility. They're part of the executive branch. And so they can grant parole through parole boards. They can do work under the probation department to recommend sentences and so on. And so sentencing responsibility is sort of spread out both between the legislative, judicial, and executive branches of governments, as you can see. All right, let's look at legislative sentencing responsibility. First, they have to create sentencing options. They do that through their criminal codes. There are what we call indeterminate sentences and there are determinate sentences. Indeterminate sentences would be something like 5 years to life. If that's what the sentencing is, it's indeterminate. That means that there is no way to actually determine the sentence. Now, it means a judge could go anywhere between 5 years and life in prison. The determinate sentences would be something like 3, 4, or 5 years in prison. So we know it's either going to be 3 years, 4 years, or 5 years in prison because that's what the legislature requires. Okay, that's determinate. It's in essence already determined as being any one of those three. All right, let's look at sentencing options. First is the rehabilitation model, and that's where there's wide discretion on what you're going to do, and it depends on how you perceive this defendant to be, what you think they need to rehabilitate themselves, and their amenability to rehabilitation also, as whether you're even going to do it at all. And then there's a due process model, which is believes that discretion will relate to inequality. That means that essentially, if you give wide discretion to the judicial sentencing responsibility, you're going to have unjust results, and that would be something. The due process model would point to the fact that black males in the criminal justice system are given a tremendous amount of more time in jail and prison than their white counterparts for similar crimes. That's a fact. There's no doubt about that. And they would bring that up, and that's because we have judicial discretion, and it's bringing about what they would say would be unjust results. Well, whether that's true or not is an issue, but that's what they would argue. Now, the crime control model would say discretion is leniency. In essence, you don't want to give discretion to judges because they might be overly lenient. We want mandatory sentences, mandatory minimum sentences, and then give them some discretion maybe on stuff that's above the mandatory minimums. All right, let's look at executive sentencing responsibility. First, we have governors, we have parole boards, and departments of corrections that are part of the executive sentencing responsibility. Governors can pardon, parole boards can parole, departments of corrections can also have some effect on what kind of rehabilitative programs that are given to people in prison or even in jail. They carry out the sentencing. So again, they can parole people. They can give them what was called good time, which is for the time that they are good in prison. That means they don't have any violations, any behavior violations. They're given a half day, for instance, of time that they can take off their sentence. And of course, there's also the pardoning authority of the governor. All right, let's have a thinking point here. Let's look at Michael Vick. Now, Michael Vick, as you know, was a very famous quarterback, making lots and lots and lots of money. I mean, on top of the world. And then he was found to have been involved in dogfighting, and pretty much, pretty involved in this stuff, where we know that dogs get killed and maimed and so on, and it's just really bad stuff. But there was an outcry that I rarely see about what his actions were, and people just wanted him to get a really large sentence. And so the question is was the sentence that he got just? It was several years in prison. And should the sentence have been longer? What do you think? Should he have been sentenced at all? Remember, he's not killing people. He's fighting dogs, so he's getting a lot of them hurt, a lot of them maimed, and some of them killed. But he's not dealing with people. So think about that. And then, do you believe his good time behavior while incarcerated should have counted towards him getting out of federal prison early? Should we have given him an early release because he acted well while he was in? Well, I'll tell you one reason why we'd like to do that. The one reason is that we have some sympathy for correctional guards who have to guard these people who are often extremely violent and very angry. Angry at society and will lash out at any government official that they can get their hands on. And so if we give them good time credits they're going to think twice about bad behavior while they're in prison. So there's something there that's kind of nice. And maybe if they are, good at while they're in prison, maybe that means that they won't be bad when they're out, that kind of thing. So there's lots of things to think about. The bad part is we're getting people out sooner than they should, and the incapacitation is being reduced. All right, let's look at probation officers and sentencing decisions that go on there. First, they will do both the supervision of the person on probation, and they will also do pre-sentence investigations. Supervision is a big aspect of probation, obviously. They have to watch over these people. They have to have them come in all the time. They have to do drug testing on them. They have to do lots of stuff to keep them from making sure that they're not doing any future crimes. But pre-sentence investigations, where they first they do an investigation of the person and the people around them, and they get statements from the victims, they get statements from the prosecutors, they start looking at what would be the likely and possibly recommended sentences for the accused, and what kind of level of supervision they should be under, if they're going to have probation, what conditions there should be of supervision, what kind of treatment plans they should undergo, and what kind of community resources are available to do so. And they make recommendations on these things as part of their pre-sentence investigation. And so courts will depend on this pre-sentence investigation. The court may not agree with what probation recommends, but they better have a good reason, because these are professionals that that are doing their best to be objective, and they know what the person has done. They know that they have been found guilty, and they've listened to all the different parties, and it's no skin off their nose if they happen to recommend something very, very high or very, very low for sentencing. And so that they're probably one of the more unbiased entities out there. The judge, for instance, and especially in the states where they're elected, is not unbiased. They have a political agenda because they want to continue to be a judge. They don't want to offend the community. They don't want to offend the prosecutor who's going to get to the news media to talk about why this judge had a lenient sentence on somebody that they shouldn't have. They don't want to give a lenient sentence to somebody and then have them go out and kill somebody either. That'll get them ousted pretty quick in an election. All right, prosecutors and sentencing decisions. First, the counts or charges can be bargained away in one form or another to limit the maximum penalty. In fact, I've actually done that many times. I will just make the counts that the person will plead to such that there is a maximum penalty that they're willing to take, and then we argue for the maximum penalty, perhaps, and then we'll let the judge decide, something like that. There are aggravating factors and mitigating factors that are involved in what the sentencing decisions are for the prosecutors. Now, remember, there's no sentencing decision directly; it's only indirectly, because of the way that they can often either reduce the amount of maximum penalty or increase it, depending upon whether they throw the book at somebody or not. But they will make a sentencing recommendation. They have a lot of influence because they're considered to be the representative of the people. And so judges look at them very seriously. If you go against a prosecutor, you better have very good reasons, and you're taking a risk. Now, if everybody agrees, then it'd be hard to criticize anybody within the system. Now, defense attorneys and their sentencing decisions. Of course, one is whether they should go to trial or plead guilty as far as their client is concerned. They will do some amount of judge shopping, because they may know that certain judges are more lenient on certain crimes, and to the extent the law allows them to do a little bit of judge shopping, that means kick off one judge in order to get another, then they will do that. They, of course, will communicate with the prosecutor, and they will emphasize circumstances favorable to the defendant so that they have a certain amount of influence on the judge's ultimate decision. Okay. All right, judges and the sentencing decisions. There are first informal limits of the courtroom work group. The judge does not want to be seen as being outside these informal limits that have been placed on these normal sentences, basically, unless there's a very, very good reason to do so, because they will be perceived as being biased and their interest is not in justice, kind of thing. And that can be make their job very, very difficult. I've actually seen judges who because they had just made the defense attorneys so upset with their sentencing decisions, every single public defender kicked the judge off of every single criminal case. They had to take that judge and transfer them to family law because they couldn't hear any criminal cases. And so that's how they can, that's some of their influence that they can have on judges. And they rely on the work group who has the most knowledge of the case and also the most experienced members of the courtroom team would be typically the judge. The judge is often either a public defender or a prosecutor, or has been in their previous incarnation, and so they sort of know the system already before they become a judge at all. All right, law and controversy. Let's look at reducing judicial discretion. The due process model advocates feared excessive discretion in sentencing, and so we should essentially not give very much discretion in sentencing because it'll be misused against racial minorities, by people who are unpopular in society, and so on. The crime control model advocates feared discretion also because it'll reduce crime control by giving judges the right to essentially give out very lenient sentences when they shouldn't. The result of the two combined is that is what we call the justice model of sentencing, where we're trying to limit the discretion of judges because we think judges are not capable of making the best decisions on sentencing. And it's interesting that both of these models agree that you want to keep discretion at a minimum, but for different reasons, of course. All right, let's look at the law in the books and the variations of determined sentences and return. First, there's dissatisfaction with the rehabilitation model. There's also a specific sentencing time that they're in favor of, and abolishing parole altogether. You should do your entire time. And it varies widely by state. It depends on whether if we have determinate sentences. It all depends on state law. You can make it any way you want, essentially. And so, essentially, what's going on here: minimum sentences. Then on state sentencing guidelines, there's a continuum of voluntary to required use. These sentencing guidelines direct the judge to specific actions that should be taken absent unusual circumstances. 21 states so far now have adopted or are seriously considering these sentencing guidelines. The typical sentencing guidelines involve the presumptive situation I just talked about for presumptive sentencing, and they still give a certain discretion to the judge because they are voluntary. They are not usually mandatory. Although in California we do have certain mandatory minimums. It does happen, and in other states the same. Now, under federal sentencing guidelines, they tend to have been very controversial than the state ones that we've seen. They tend to be very, I guess you'd say, stern, to say the least. There are legal and political factors that lead to that. In 1984, for instance, Congress created the U.S. Sentencing Commission and charged it with developing guidelines for sentencing federal offenders. And these became these standards actually became the law in 1987. The Supreme Court upheld their legality in 1989 under Mistreta versus United States, and then only to rule them unconstitutional again in 2005, interestingly, in the United States versus Booker. In the first part of the complex opinion in 2005, the federal sentencing guidelines were found to be unconstitutional for the same reason used to declare state
sentencing guidelines unconstitutional. Congress improperly allowed judges and not juries to make the key factual decisions in sentencing. But the second part of the opinion also allows federal judges to continue to use sentencing guidelines as advisory, and appellate courts can review for reasonableness. So again, the United States Supreme Court has decided that you can't take away a lot of the discretion of judges, and you have to also give some of that to juries. Now, let's look at law in action and the diverse impacts. Several states investigated the impact of sentencing schemes and found that the impacts were quite diverse. Although the specific impacts of these laws varied from state to state, the overall pattern became quite clear. The overall prison population increased mightily. That happened in California for sure. We were actually triple bunking people in our prisons because of the large number of people who were being sentenced to state prison. And by themselves, structured sentences, these schemes appear to have little impact on the overall incarceration rates. In contrast, determinate sentencing laws alone, although the abolishment of discretionary parole release can lead to lower incarceration rates, since they limit the ability of the correctional officials to deny parole. The combination of both presumptive sentencing guidelines and determinate sentencing schemes offer the most control over incarceration rates by impacting both sentencing and release dates, as it turns out. So there are some real effects, to say the least, of these sentencing guidelines. We're looking here at Minnesota sentencing guidelines for different kinds of crimes, from the murder second degree, murder in the third degree, and then it goes down to lower ones. These would be the non-capital offenses. Felony DUI, and those go pretty high. It could be, it depends on their background, but they could go up to, looks like, it's 36 months to begin with, and goes to 72. 72 months, 6 years, basically. All right. Now, let's look at Kimbrough versus United States. What happened here was the court held that the trial judges may narrow the sentencing gap between crack cocaine and powdered cocaine. And then 3 years later, they found another case of Pepper versus United States. The court further expanded the discretion of federal judges at sentencing when they held that when the defendant's sentence has been set aside on appeal, a district court at resentencing may consider evidence of the defendant's post-sentencing rehabilitation. So the benefit of the fact that they have been in prison for a while and that they may have gotten some good marks on their behavior, for instance. But what happened here is Kimbrough was arrested in a very crime-ridden area for crack cocaine sales. He pled guilty. The U.S. attorney sought 19 to 22 years according to federal sentencing guidelines. The judge said that the statutory minimum was 15 years, which actually is not true, because the court had already decided that the federal judges only use those guidelines for advisory purposes. The federal sentencing guidelines were unconstitutional if mandatory, as we said, and Congress changed the sentencing laws regarding different forms of cocaine. So essentially, what's happening with the United States Supreme Court is they're saying that federal judges are entitled to quite a bit of discretion. And yes, those sentencing guidelines are there, and they can use them as a base if they want, but they're going to have to weigh the mitigating versus the aggravating circumstances, and they're going to have to decide on what is the fair and right sentence for that particular defendant on every case. That's essentially what's going on here. And the United States Supreme Court has also struck down state sentencing guidelines on the same basis. Okay. All right, let's look at the mandatory minimum sentences. These are offenders convicted of offenses that must be sentenced for a particular period of time, not less than a specified number of years. Your three strikes laws is a good one in California. We have, for a two-strike case, we have double the amount of years on a determinate sentence. So if you have a 3, 4, or 5, you're looking at a 6, 8, or 10. that you'll get for a 2-strike case. And a 3-strike case is just automatically 25 years to life. And in each of those 2 cases, you have to do a minimum of 80% of your time before you can be paroled. And this also includes the truth in sentencing laws we've already talked about. Let's look at a thinking point here on sentencing schemes. It'd be a good idea for you to research your state laws and determine if they have a 3-strikes law, first of all. Are there any mandatory minimums? And is there any truth in sentencing laws as part of your state scheme? Do you agree with the 3-strikes law if you found one? If you don't find one in your own state, what do you think about California's, by the way, that on your 3rd serious or violent felony, you will be sentenced as a minimum to 25 years to life. That is, in fact, the only sentence you can be sentenced to. And you'll do a minimum of actual 20 years before you can be paroled. And then who are the people who normally get these kind of sentences? And what are the advantages of having these kind of sentences? And could they be used in a discriminatory way against racial minorities, for instance? Let's look at the law in action, nullification by discretion. Essentially, sometimes we will look at a case and say, even though this is a 3-strike case, I'm sorry, that's way too much time for this kind of case for what actually happened here and who we're dealing with. And this can happen in a number of different ways. First, the police arrest would be the first nullification by discretion. They could say, you know what, I'm sorry, I'm not going to get you involved in, I'm not going to essentially refer this case to the prosecutor because if we do, you're going to get a huge amount of time and it's really not justified. So your first discretion post, so to speak, would be the police itself. They can make it so that it never happens. It never gets anywhere. They don't investigate the case. Then there's prosecutorial discretion. So, for instance, you may have a 3-strike case, but they plead only 2 strikes, and so you're at double the base term at a minimum, but you're not doing 25 to life either. You're not doing even a life sentence. You're doing a determinate sentence in California. And then there's, of course, juries, the conviction. They can nullify. They can refuse to convict even if they know that the person committed the crime because they know that the penalty is so high. I actually had a defense attorney argue that this was a 3-strike case and it's just too high of a penalty for what this guy did. Of course, I asked the judge to admonish the jury that they should not consider that in the guilt phase, but he'd already done it before I could stop him. And so they now were considering nullifying, which they did not do, as it turned out, but they could have, on the basis of this is too big a penalty for someone doing this kind of act. And then there's judicial sentencing, where they can do a number of things to, they can actually dismiss counts, by the way, even though they'll find themselves in a real world of hurt if they do, and you'll have a prosecutor very angry with them. They can do it. They can do many different things to make this happen. They can even put out an illegally lenient sentence and then let the prosecutor appeal. Let's look at the law and controversy and the negative side effects of all this. The first thing that you need to know is that one of the reasons why legislators will want to put in additional increased penalties for crime is because it's sort of a great no risk situation to them. They don't have any additional appropriations they have to make, so no additional taxes have to be levied for the additional time that these people are going to be put in prison, but they look really great to the public that they're fighting crime real hard. So it's a great idea for legislators to do that. But there's a number of studies that have suggested, although not necessarily proved, but suggested, that increasing the severity of punishment produces negative side effects. One of the negative side effects of increased severity of punishments centers on the greater time, effort, and money courts must expend. So what happens is if you have these very, very large penalties, especially like in the 3-strikes areas, you're going to get a lot more trials because the person has nothing to lose. And so with more trials means more time of court time, more effort, more resources, more money, and we got some problems, additional problems. Also, Some critics have been concerned with mandatory minimum sentencing legislation because it results in rigid and inflexible reaction to problems of judicial discretion. Essentially, they're saying, it's like using a sledgehammer to thread a needle, because there'll be cases where you'll regret having the minimum sentences, and justice will not be done. And the reason why is because you took away the discretion of the judge. All right, what sentence should be imposed? That's the next question. That is a very difficult question, and it involves so much of what crime was committed, how aggravated that was, how cruel of a heart the person has that committed the crime, how much the victim suffered as part of the crime, how often this has been done. In essence, is this a recidivist defendant, or is it someone who's done it for the first time? Is this anomalous conduct by the defendant, or something they've been doing pretty much regularly throughout their lives? These make big differences in terms of the sentence. But we have a limitation under the Constitution, the cruel and unusual punishment limitation of the Eighth Amendment, and that is binding on the states. And so the United States Supreme Court can strike down a sentence that is too cruel or unusual in state sentencings. So let's look at the types of sentencing, of course, that you can have. You can have imprisonment, which is send you to actual state prison or federal prison if it's a federal case. You can give someone probation. You can give them fines. You can order restitution, which is paying back the victim their out-of-pocket losses from being victimized. And there's certain intermediate sanctions that can also be imposed. Sometimes we think that prison is too harsh and unjustified and unnecessary, and when that happens, we look into other range of possible sentences. This could be community service. It could be home confinement, intensive supervision by probation. Could be boot camps for behavioral problems, and maybe jail time with release into a program if they've got a drug problem that's causing them to get into trouble. In essence, we can do lots of things in between all these things. So we could give probation, but a certain amount of jail time, a certain fine, restitution, not send them to prison, for instance. Let's look at imprisonment. One of the problems with imprisonment is that we have too many people in prisons throughout the United States. In California, we had to pass AB 109, which ended up taking about 40% of the population out of prison, and we suffered greatly for that for a number of reasons. The correctional system didn't always decide on the right people to release, and we end up getting some murderers back on the street, and they end up committing some more murders. Lots of rapes have occurred as a result. When they didn't have to release those people, what they did is they didn't realize that the crime the person had been imprisoned on for the current imprisonment was maybe a drug charge, but the person had numerous rapes, maybe a homicide in their background, and they didn't realize they should have looked more into the background of the person to see who they should have released. In any event, there are a number of conditions of confinement lawsuits because they're considered cruel and unusual. Punishment, basically you have a certain minimum standard that you must meet, and you can be sued for violating that. People who are hurt in prison when they could have been protected, those will get you lawsuits. The state will have to pay. They're very high cost. In California, we're looking at about $49,000 per year per person in prison as an average cost. The realities of imprisoning large numbers of criminals force states to look at alternative sanctions because, as happened in California, we were triple bunking people in order to house them in the prisons that we had. And we had, back in the 1980s, already put out bond elections for building new prisons. And building new ones additional new ones would have just been unthinkable. And so we had to empty a large portion of the population. We just couldn't do it. So they took those that were involved in drug counts, especially possession of drugs, and threw them out of prison. almost overnight. All right, so adults under correctional supervision in the United States, if you look at those who are in prison, which is this squares here, we're looking at about 1.5 million people out of in excess of 300 million, probably approaching 400 million now. But it's gone up from back in 1980 from less than probably 400,000 to 1.5 million in essentially what is 35 years. Of course, the population has not gone up what is essentially 4 times, and that's what you've done. You got a 4 times increase in the prison population. This is obviously a reaction to the large amount of serious crime that was going on back in the 1980s. So you're seeing a large number of people being put in prison as a result. All right, let's look specifically at probation. It's the most commonly used sanction in the United States, very common in misdemeanors especially. And defendant will likely not commit another offense if they're properly monitored, if they are amenable to probation, if they just really don't want to do it, and they can be monitored, they will probably not be involved in another offense. And quite a number of people who would get probation are not. It's also to the public interest, and the public does not demand that the penalty be required. Rehabilitation of the defendant does not require the penalty for the offense, so that essentially what you're doing here is you're giving a person a chance to not have the full sentence brought down on their head in exchange for a period of monitoring that requires them to certainly not commit another crime, but do a whole bunch of other things to get their life back in order like it was not before, and which led to this crime being committed. And we find that it's much, much less expensive to keep people on probation than it is to put them in jail or prison. And it can operate to also, in a sense, incapacitate, although not actually, because there's not perfect supervision, but it makes it very difficult for probationers to commit new crimes because probation departments can go into their house anytime and search their house, find out what they've been doing, stop them on the street just randomly, and see what they're up to. And so you're always out there under the watchful eye of police and the probation department, because police, once they stop someone, let's say on a traffic stop, they'll see if they're on probation or not, and if they are, they'll search their car almost automatically. And that's because, well, okay, we got one here, let's just see if he's in trouble or not, because if they are, we need to protect society, and if not, everything's good. That's the way it goes. Fines, it's one of the oldest and most widely used forms of punishment, and there can be fines based on severity of the crime, but also the wealth of the defendant. Giving a fine that someone can't possibly pay doesn't really make a lot of sense because they're not going to pay it, and it won't end up being a penalty. But if it's enough of a fine that it'll hurt every month, it can have its effect because it now makes the crime cost money. And if they're able to make money, there's somebody who makes money, then it becomes a pretty good sanction. I found that to be true of corporations. We use civil penalties to go after corporations to punish them. That's the only thing that works with corporations, of course, because a corporation is not a real person, but they do not like having to pay what are essentially criminal fines, and in large amounts for regulatory violations and so on. Okay, look at restitution. Restitution in California is actually the right of the victim under our Bill of Rights law, and that was enacted in 1982. Any victim who suffers an out-of-pocket loss as a result of a crime is entitled to restitution from the offender, and so there will be essentially a civil judgment ordered against the offender to pay the victim back for their out-of-pocket costs, which can include psychological counseling, doctor's bills, loss of property that got destroyed as part of the crime, and so on. All right, intermediate sanctions could be community service. It's symbolic restitution. You're basically giving back to the community for having violated their important laws. You can have intensive supervision on probation, and this will target the ones that are likely to go to prison on their next offense to try to keep them on the right side of the line. And it will usually involve home detention, so they have to be at home except when they're working or going to a doctor's appointment. There'll be electronic monitoring. They'll have a device around their ankle so we can tell where they are. If they go off site when they're not allowed to, it'll alarm and probation will be out looking for them. There can also be GPS monitoring so we can actually see where they are at any given time. And then boot camps are another one. This is often used for people who have behavioral problems. We essentially put them into a military boot camp kind of arrangement, and it's sort of what we call shock incarceration. They're not allowed to leave, and they're put through very rigorous athletic and other kind of training, and usually to keep them understanding the importance of self-discipline. All right, people who have been executed in the United States. You can see back in the 30s it was not uncommon, and they dropped in the 1960s. Through the 1980s it was almost zero. This was a time when we were questioning whether we should have the death penalty at all. There were some states that had decided that it was against their own constitutions to have the death penalty. It was considered cruel and unusual punishment, and that actually happened in California. Interestingly, in California, though, when that happened, the populace got very upset and de-elected our Supreme Courts, because our Supreme Court is not lifetime tenure. They are elected. They de-elected and recalled every single justice on the Supreme Court and put new people in there. And lo and behold, back came the death penalty. It was now found to be constitutional. And so you'll see it in California. And then we start seeing a peak around the 1998-2000 range. That was probably in response to a lot of the violent crimes that were going on in the late 80s and the reaction to it. And we're seeing more of it now. It's gone back down to a pretty low level generally. You see a few here and there from time to time. All right, the death penalty, of course, is capital punishment. The Eighth Amendment standards. First, let's look at Furman versus Georgia from 1972. It said that all existing death penalty laws were invalid, and it basically, because you could get death for just first-degree murder, and that's not always appropriate, and so they just wiped out all state laws and made them make new laws. It also required a bifurcated trial. And what that means is you will have a trial on the guilt phase of a murder case, and then you'll have a second trial on the sentencing. So you're going to have the jury looking at sentencing. So a jury has to convict of the crime and then also recommend the sentence of death before you'll have death sentences under Furman versus Georgia. And Gregg versus Georgia, death penalty laws are not always unconstitutional, they decided. Mandatory death penalty laws were struck down, and again, the bifurcated process was required back in 1976. So we're seeing the United States Supreme Court throwing in a bunch of new requirements for the use of the death penalty. Then they got into the method of execution. They found some of the methods to be cruel and unusual, and it came down to whether they're going to suffer any pain. Hanging was taken out, obviously. The electric chair was also taken out, and now we're dealing with lethal injections. And now they're finding out certain drugs are not considered appropriate for that, and others are. And there's been quite a bit of litigation over what drug to use and how it's to be administered. And there's also a narrowing of the death penalty eligible cases. First, there's crime limitations. You have to have certain types of crimes. You have to have something more than a first-degree murder. You have to have usually what in California we call special circumstances, which include things like lying in wait, murder for hire, killing more than one person in the same event, that sort of thing. In essence, has to be a very aggravated murder case. There's also developmental limitations. You can't sentence a mentally retarded person, for instance, to death. We don't hold them as responsible for killing people as we do a person who has their full faculties. Also, lengthy appeals, and there's evolving standards that going on. And the reason why there's very lengthy appeals
is that you have a state court case for murder. There's a death penalty imposed. Then that case will go through the state appellate courts, which usually is one appellate court and one Supreme Court. And then if there's constitutional issues, and there always are, there's an appeal that's available to the federal system. So they'll go to the federal district court, then they'll go to the Federal Court of Appeals, and then if the U.S. Supreme Court will allow it, they will go to the United States Supreme Court. So you can go through 6 different courts. And by the way, they can send cases back for different kinds of rulings, and then it comes back through the system again, through the same 6 courts, and so on. So it's a very lengthy appellate process. You can easily go 20 years before you can finally run out of options. Okay. There's also cost concerns. It's very costly to keep people on death row. It's also very costly for the appeals, and so it's something that's a serious problem. It makes it so that it could cost millions and millions of dollars to get one death penalty imposed. Let's look at courts, controversy, and the judicial administration. So let's ask this question: should the death penalty be abolished? What do you think? Many people are of the mind that it should be. It's just it shouldn't be a penalty that we should administer because it's making us being as barbaric as they are, kind of thing. Other people think that's the proper way to deal with certain very high crimes, although they may think that it has to be a very aggravated crime. They think that the death penalty should be around. And probably the best support they would have is, what about the shooter on the Las Vegas Strip that killed so many people, assuming that he was alive and was tried for the murders that he committed. Can you think of anyone else who might be more deserving of a death penalty? And then think about what offers the best grounds for keeping the death penalty. What are the best reasons, if you had to be on the side of the death penalty, what reasons would you give as your best reasons? And then do you think that the issue of innocence on death row justifies a moratorium on the death penalty? In essence, we do occasionally find, and hopefully it's occasionally, and it has been just occasionally here and there, that people who have been found guilty of murder and on death row were found to be innocent. Now, by the way, they probably had something to do with why they were convicted. Often it was they were confessing to a crime that they did not commit, but they were protecting somebody else. So it wasn't the system that really failed there so much as the situation that failed itself. But there are some where that didn't happen. So they were just convicted and they did not do the crime. It was found out later they did not. All right, let's look at a close-up on a case, Rupert versus Simmons. And that was a case on whether we should put juveniles to death. These are people under 18. In this case, Simmons had deliberately drowned a neighborhood girl who had befriended him. At 17 years old, he was too young to understand the crime he committed. Was he really? Well, we say that kids can't really understand what they're doing. He's technically a kid, although he's very close to being an adult. And the court just simply decided the Eighth Amendment forbids the imposition of the death penalty on offenders who were 18 when their crimes were committed. 18 or excuse me, under 18 when their crimes were committed. 18 is old enough to vote, marry, and serve on a jury, so that is good enough to call you an adult. Now you're ready for the penalty of death if it's appropriate. All right, what are the normal penalties? Let's look at this. This is kind of important. This has to do with the work group. As we all know, we get the judges and the prosecutor and the defense attorney and sometimes the probation officer to get together in a work group and decide on what's the fair and proper sentence for a specific case as a way to try to resolve that case short of a trial. And so, let's think about this. What would be normal penalties? Could this group come down to normal penalties? Yeah, they certainly can, and they do. What happens here is many of the cases that come before them are very similar. If you get a residential burglary, they're often done the same way, with the same motives, often with the same kind of people, with the same kind of very similar backgrounds, who do this kind of stuff. And so, you start with a normal penalty. You start with the base term, or what's called the middle term. And then you work your way from there, defense attorney throwing in all the mitigating factors, prosecution throwing in all the aggravating factors, and then we can kind of figure exactly where it should be, generally speaking. And judges also consider aspects such as seriousness of the offense, the prior record, and other aggravating and mitigating circumstances when they actually make their decision in the work group, as well as if someone goes to trial and loses and now they have to decide the actual sentence. But it is one of the most difficult jobs of the judge is sentencing for many reasons. Not only is it hard to really figure whether you got the right one, but it's the one that's most politically charged. And if you're a state judge that is elected, it makes it that's the part where they really get upset, because if they don't get the right sentence and this person goes out and does some serious, terrible thing that they could have prevented, then they're going to be on the wrong side of their election next time. All right, let's look at seriousness of the offense. It is probably the most important factor because it takes into consideration how much the victim was harmed or could have been harmed if they didn't actually get harmed. There are sometimes cases where, you shot at somebody, you wanted to hit them, and you just, you hit them in the arm instead of in the head, and they're injured, but they're not dead. That's a very serious offense. You tried to kill them the best you could, and you happen to have failed before someone stopped you, but a very serious offense. So we do look at the harm or potential harm to the victim as a very important part of the seriousness of the offense. And most courts will use a rank ordering. The most serious would be the armed robberies, the rapes, murders, all that sort of the big 12, so to speak. Mid-level would be domestic violence because it usually leads to a lot of other crimes that are of serious nature and end up a lot of times having the victim being killed. Lowest levels are the forgeries, thefts, and burglaries. In terms of their normal, these are theft crimes. These are things that, yes, the victim's hurt financially, but they're not hurt physically, and so they're usually ranked lower. Prior record is the next probably most important factor because you're looking for whether you've got a first offender or you've got a true career criminal. So this the factor is looking at essentially who we have in front of us as a criminal or someone we think may have done some sort of anomalous event in their lives, something that will likely not repeat itself. So prior record has to do with their prior criminal record. So a first-time offender would be, of course, looked at very differently than a career criminal that's doing the same crimes over and over and over again. Also, we look at the length of time between offenses. So it's possible that we may have had a criminal with a record, when he was 18 to 20, and it stopped for 40 years, and then all of a sudden he's back at it or back into criminal conduct of one sort or another. We'll take that into consideration also, because it may have been that he sort of turned himself around and that another anomalous event occurred. But this is a very, very important factor because we will have to hit someone much harder if they are a career criminal than we would if it's a first-time offender typically. Now, the aggravating factors, and there are many, by the way. There's no limit to the aggravating factors or mitigating factors for that matter. It can be anything. Use of a weapon, injury to the victim. This is just the scariness of the crime, how much violence was used, how callous the person was in their use of violence, and so on. Mitigation could be the youth of the defendant himself, lack of mental capacity, could be another mitigating factor. The role of this person in the offense. If this were a wife of a drug dealer who was required to mule the drugs for the husband, under penalty of domestic violence and possibly even death, well, that makes a different situation altogether than someone who is the drug king himself, kind of thing. And then their social stability. Have they led a life of social stability in the past? Have they had a job? They kept things going, basically, and, kept things going in the legitimate world anyway, for periods of time and so on. Especially if someone is, makes a lot of money, is been legitimate their whole lives, it's a very big mitigating factor for sure. All right, let's look at law and controversy, uncertainty, and public opinion. Sentencing is no mathematical formula by any means. It is a very difficult thing, as judges will tell you, to get the right amount. We never know if he did in any event, but It is just very, very difficult. And it's really an art. You get better at it as you do it, and there's no calculus to it. Only mistakes resulting in harm will reach public attention. So typically, the public expects that sentencing will be carried out, people will be given appropriate sentences, and so on. And the only time we see these getting out there in the media is when the media finds out that someone just, let's say, smashed into a family of 5 driving. The guy was DUI, and killed the whole family. And then we find out, well, the judge just let him out of custody on bail from a previous DUI. Now that's going to get in the newspaper, and that's going to cost the judge politically probably his job, if that was ever seen. So only mistakes resulting in harm will reach public attention because that's the only one that our media are interested in, essentially. All right, differences in sentencing outcomes. This is one of the more confounding areas of sentencing because it brings in what are considered, discriminatory sentencings for racial minorities, for different genders, different types of people in different groups. And they start, it's really easy to put these people in certain groups, and there are studies that have been done that are pretty good in terms of being able to decide on, what a person's race was, what their gender is, what their background is, and they can easily categorize people in certain groups, and then they look at the cases that have been prosecuted against these people. They compare them, to the white Anglo-Saxon Protestant type to see the differences in sentencing for the white Anglo-Saxon Protestant versus the people who are in different groups, including racial minorities and so on. And then they start making claims that this imbalance, which you'll find often is the case, is because of just out and out discrimination. The system is against them, kind of thing. And there can be some truth to that, but at the same time, the people who are committing these crimes are often committing very, very heinous crimes, and doing it in a very cruel and unusual manner. They are more desperate. They typically have a much larger criminal record in their background, all deserving more time because of those things. And so that's the one thing that is not brought into these the imbalance in sentencing kind of studies is who are you dealing with individually? If you had let's say a white Anglo-Saxon Protestant and he did a residential burglary case, that would be unusual. Probably this person may have had a job. They may have been in the legitimate world for a very long time. This may have been the first offense they've ever got caught on. They had no criminal record in their background. And you compare them to, let's say, a black defendant who has been doing burglary since he was a juvenile, continues to do them into his adulthood in 30s and 40s. So he's a career criminal. He beats people up mercilessly in connection with his crime, so that when he burglarizes places, he tortures people and beats them up and so on. That's a different case. So that's one of the things that's just not there. So we look at if we look at though the actual imbalance, poor young minority males, typically black, are disproportionately represented in the criminal justice. It also includes Hispanics, but they are definitely disproportionately represented and disproportionately given higher sentences. That part is not even a single doubt about. The question is whether or not they were deserved sentences based on what they were doing, who they were, and that sort of thing, versus the ones that they're trying to compare them to. That's the issue. And they use legally relevant variables in the cases, but they don't really look at the actual person who got the sentence and why the judge hit him hard with a sentence. And if they did, they would see that they are typically a career criminal. They have been doing it for a long time. They are not remorseful for their crime whatsoever. They are, quite capable of doing this again, and when they get a chance, they will do it. And that's a different thing. So comparing similar cases is actually very, very difficult. It would be very difficult to find people who are very similar in their makeup. And it is all personal in terms of what kind of sentence you get, because we're looking at the person, not just the crime, but the person themselves and who committed it in terms of what they should get. All right, so inconsistencies in sentencing resulting from, are resulting from the decision-making process. So it is all done by judges and prosecutors, defense attorneys, and all those people involved in the sentencing. That's true. And we also find that the most common disparity are due to geography and judicial backgrounds and attitudes. And yes, I'm certain that there are certain judges who have come to find in an attitude that if you're dealing with a, let's say, black, young, poor black defendant or young, poor Hispanic defendant, that they are people who, they'll say in their own minds that these are people who are career criminals, even if the evidence doesn't necessarily say that. So I know that some of the discrimination is actually going on. There's no doubt about it. But how much of it is very much in controversy. All right, geography of justice. Frequency of punishment varies by county and state. It depends on how much crime they're having and of what kind. So if they're having a very, very bad problem with residential burglaries, they're going to be hitting those really hard. If they are not having a particularly difficult problem with residential burglaries, they're not going to hit it quite as hard. Also, police effectiveness. How effective are they in catching the people who are committing the crimes? Are we getting lots of people in the system or just a few? What about the screening procedures they go through? You know, police deciding on which cases should or shouldn't be prosecuted. What about the prosecutor as well? Some of those are screening out a lot of these cases. And then, of course, the types of defendants that are involved. Those become very important in terms of punishment. The South is harder or harsher in sentencing than the North, and they tend to be, you know, you do something, you're going to get punished badly for it. And in the North, they would tend to be a little bit more lenient, or tend to be. Let's look at a thinking point. Stacey Humphreys. Why don't you research the case of Stacey Humphreys, a Georgia inmate? The county in which he committed the crime agreed to move jurisdictions to South Georgia because the victim's fiance was a police officer in the county where the crime was committed. Do you think that's fair to move the case to a different community? Fair to the defendant, fair to the system, to the prosecution, which is essentially the representative of the people? Is that fair to have done that in this case? Remember, this is not pretrial publicity necessarily, where we wonder whether we can get a fair jury. It's a matter of there would be maybe some elements of the police and prosecution that would be out to get him, kind of thing. Well, you're not going to change the prosecutor regardless, and you're not going to change the police officer witnesses, so that doesn't seem to be justifiable. But getting out of the jurisdiction, it probably would not work against the defendant, because if the new jurisdiction within the state, doesn't really know who this person is, doesn't know who the police officer is, then that should work to the benefit of the defendant, should make them more unbiased, and we'll get out of that kind of problem. But to what effect would the case have ended had the jurisdiction not be moved? Would this have been different? Do you believe it's possible that because this case was moved, a judge was more lenient or more harsh in that case? This is a case that you see in your book as well. So think about these questions, because this is part of the system and part of what we do to try to make things fair. And sometimes we might not do so because of these kind of problems. Let's look at judges' backgrounds and attitudes. We know that U.S. District Court judges appointed by Democratic presidents tend to be more likely to find for the defendant. We found that to be true. And there are certain perceptions of seriousness of crime that are different between judges. Some judges see certain types of crimes to be very, very serious, and others think it's not quite so serious. Like, for the best example I can give you is some judges think that the sale of drugs and the use of drugs is one of the biggest problems we have in our society. We have to hit it really, really, really hard. And others say, well, that's just what people do. If you want to get high, you're going to get high on one thing or another. They just choose drugs instead of alcohol. There's more problems we have with alcohol than we have people that are selling drugs. So I'm not going to hit it so hard. And I don't want to spend money putting somebody in prison for these crimes. And, so their backgrounds and attitudes do make a difference. So who we choose for our judges does make a difference in terms of how they will sentence. And that's why in California, it's not unusual to see district attorneys and deputy district attorneys being elected as judges, because the public assumes that they'll be hard on crime. All right, discrimination in non-capital sentencing. Well, there's lots of them. Economic status, we know. We've seen this. Although the O.J. Simpson case was not a capital case. And his economic status, his celebrity status, there was discrimination, all right, but it was not against him. It was for him. But it can be the other way around. It could have been if he was a poor black person and he was subjected to the same case that he was subjected to, he probably would have been found guilty. And that's because why? Because juries and other people making decisions in cases think of a person who with very low economic status as not being quite so important. People with a higher economic status are considered to be more important, which is really unfortunate. But it's a natural thing that people think, and it does get its way into the criminal justice system. The gender of people involved can also be very important. We'll find that if we have a woman, we're going to not hit her nearly as hard as a man for the same crime. Race is very important. That has to do with the idea that some people perceive people of a certain race to be more likely to be criminals than those of another race. Not a good idea, but the idea is out there. It's an attitude. It's sometimes one that is even concealed from the person themselves. They don't realize they're doing it, but they're doing it anyway. Age is another one. We tend to be lighter on people who are older and a little harder on people who are very young, because we think if we hit them hard when they're young, we'll be able to stop them. It's hard to put an 80-year-old away in prison for 20 years. It's a bad place to put them in the first place. But if they do some serious crimes, I guess we challenged on that one, but we still would tend to not want to put them in prison. There's also the effects of intersectionality. So the concept of intersectionality is the idea that first we see in our studies the disproportionate nature of sentencing when we're dealing with race and the normal things that we would normally be looking at, ethnic background, all that sort of thing. But then when we look at other variables in addition to those variables, such as age, gender, education level, employment, socioeconomic status, then we find even larger and more significant differences in the sentencing. So we're seeing that you could be a black woman, older, let's say an elder, well-educated, employed, and doing well in the socioeconomic status, and your sentence is going to be radically different than another black person, just generic black person, generally, or if we averaged all the black people out there, your sentence is going to be radically less than, and I mean radically less than the average sentence for a person of your race, for instance. So we're seeing some effects of when we add in these so-called extra-legal variables such as age, gender, education level, employment, socioeconomic status, it really skews everything. And my personal opinion is that the age, gender, educational level, employment, and socioeconomic status are that important to people when sentencing comes up, and to judges. And if juries are involved in it, the same to them as well. Those become very, very important, much more important than probably, well, I can't say much more important than every other variable out there, but it becomes very important. So we see this effect in the studies as well. All right, let's look at discrimination and capital punishment. The law is not supposed to be biased, we know that. We also know there's discretion in the criminal justice system. We know that there can be bias in the discretion that's given to people in the criminal justice system. And so we see that there are conflicting results in the research. Conclusion may be that discrimination is not overt, but is subtle and is indirect, and has indirect effects. And so it might be difficult to call it out as out and out discrimination, at least conscious discrimination. It may be unconscious, subtle, just there because it's in the back of people's minds, often hidden from themselves, and so on. So we also have an offender-victim dyad. This is let's say you have a black offender and a white victim. This is most likely to be one cases where we're going to see capital punishment. And again, this is going back to old ideas that have been around for hundreds of years, and they're still around. And they, again, often are unconscious, but there, even in people who think that they would never think that way, are actually, if you could somehow see what their thinking is in their background, there's some thought like this going on. If it were a white offender and black victim, well, probably you would not receive the death penalty, which is the opposite side of the same coin. And that tells you some of the thought processes that are going on when sentencing is considered. Also, studies indicate that racial discrimination and use of capital punishment is in the South most exemplarily. Yes, that certainly makes sense because, what was it, in the 1960s? We were still fighting in the black movement. It was just starting out with vigor, and it's since calmed down a bit, but the ideas that were there then are still around. There's been evidence in discrimination since the Gregg case also that you have in your book. Race is found to be a significant factor in sentencing, certainly. So your Hispanics, your blacks will tend to have, if you take every one of the one on the same crimes as for whites, a significant difference in the actual amount of sentencing for each of those people, or at least on average. Evidence of no discrimination since Gregg, well, we do use more sophisticated analysis. It has revealed important legal factors. But one of the more interesting aspects of the death penalty was that if you had a prior relationship with the victim, that is, the perpetrator and the victim had a prior relationship, you were much less likely to get the death penalty than if it's what they call non-primary homicides. These are homicides done during the commission of another felony, like armed robbery, where someone gets killed as part of the armed robbery. Those you're likely to get very, very high levels of death penalty for. It tends to make sense, although you wonder why, because there's a prior relationship, a person should be given a break. But what really happens here is that if you were afraid of something, it would be, being killed in a armed robbery kind of a situation, or a rape, where you get killed as part of the crime itself. That's the kind of thing you see on television, in horror films, and that sort of thing. And so it just, curls the hair on the back of your neck kind of stuff. And that's why we get juries reacting that way. Prior relationship, I'm not exactly sure why people would think that that makes a big difference, but it does. Statistically, it does. And then in McCluskey versus Kemp, they decided that the system of imposing capital punishment in Georgia was still valid, even though there would be probably, obviously, some inequities involved in the application of the death penalty. They just basically threw out the social science evidence, which were the studies of the disparity in the number of people who were given capital punishment and under what circumstances. So in essence, they were saying that statistical studies are not going to tell us how just our system is. And the reason why, of course, is because you can't really take one case and compare it to another truthfully. You're comparing apples and oranges. You're dealing with different defendants, different aggravating factors, different everything. There's no such thing as the same case out there. And so they're not going to let social science essentially decide the case for the courts. The courts will have to decide that on their own. Okay. All right, that's it for sentencing. Again, it's been a long chapter. I'm glad you were able to keep going and get through all of it. And again, if you have any questions regarding the learning that we have in this chapter, please feel free to email or call me, and I'll be more than glad to help.